The first mitigating factor that would be raised by the defense counsel would be the age of the offender. In the case of Turkiran bin Taib versus PP, the court held that any offenders in between the age of 17 and 21 years old should not be imposed punishment under imprisonment, but instead they should be sent to an approved school such as Henry Gurney School. However, this view was not followed by all the court, as the prioritization was not given towards the age of the offenders. Instead, it was given to the gravity of the offence committed. In the case of PP versus William Ayau, the gravity of the offence committed was serious. The accused, who was aged only 19 years old, had raped his niece, who was only 13 years old, and the court held the punishment granted by the session court, which was imprisonment of 5 years, was definitely insevere to the nature of the society. It was definitely dangerous to the society, as it was not an accurate punishment granted upon the rapist, who was only a 19 years old male. The next factor would be the record of the offender. In the case of PP versus Mark Kodiam, the accused was a member of parliament who was charged under sedition. However, he was a first offender, and it was the strongest mitigating factor for him, as he was released under a good behavior bond. It should be noted that not all clean records will discharge the accused upon the offence committed, especially under drug trafficking cases. In the case of PP versus O Lee Swee and other case, where it was held that death penalty is mandatory under drug trafficking case, which will be charged under 39B of Drugs Act 1952. Moving on to the next point, which is plea of guilty. In the case of PP versus Syaritan anak lelaki Pacamutu, the accused was sentenced to 6 years of imprisonment, and he had a good record towards his police officers, who had pleaded guilty together with 10 whipping strokes. In the case of Sosainadan versus PP, Augustine Paul opined that if the trial judge fails to consider the plea of guilt which had been admitted by the accused in the trial itself, then the appellate court would have to interfere in the sentencement of the accused upon the punishment granted. Next factor would be that the gap of the principle. In the case of R versus Goodwins and Wilkinson, the court held that in deciding the sentence of the punishment to be granted upon the accused, the matter of the period of the honest work between the termination of the previous conviction and the present conviction will be taken upon consideration by the court. In the case of Morgan Mardamutu versus PP, Viti Singham held that the session court fails to take into consideration the mitigating effects of 16 years gaps of his previous conviction and compared with the past conviction, which was under the same offence, which was charged under drug trafficking offences. In the case for the factors under conditions which will be imposed before commissions of offences, let us take a look under drunkenness. In the case of Raja Izzuddin Shah versus PP, the accused pleaded that he slapped the police officer as he was drunken and he was not in conscious state. Thus, the court released him upon his offence committed, in order that he had to pay compensation towards the victim. Under consent, in the case of PP versus Selva Raja, the victim who was in trouble has asked permission to stay upon the accused's house, and where he raped the victim, and later on the victim had only reported the rape case after 3 years lapse of time. And there are also other cases such as domestic and financial crisis, which could be fall under this factor as well. Moving on to the effects on conviction and sentences, it can be seen under effects on family members. As we could see in the case of Chan Hit Sung versus PP, the accused was reduced of punishment, where he had a family and 5 children to be supported financially, and he was also looked sickly as he was aged more than 38 years old. Moving on to the next point, which was effect on job and other privileges. The court held that, besides the privileges or any other reputations that would be spoiled upon the punishment granted upon the accused, however, it should be balanced between the public interest as well. In the case of PP versus Vijaya Raj, the accused was a headmaster and he was imprisoned for 1 day and fined of 2,000 ringgit as he was dealing with misappropriation of funds in the school. The next factor would be the conduct of the offender, where we can see by the cooperation with the police. In the case of Syaritan Analalaki Pachiamutu, the accused was said to have a good cooperation with the police officer as there was a wanted reduction of his imprisonment period. And there was also a factor under payment of compensation, whereby the accused ready to pay 2,000 ringgit to the victim, and there was a reduction of sentencement upon his imprisonment granted by the court. Moving on to the aggravating factors which will be submitted by the prosecutors in the court. The first one would be the prevalence or rampancy of offense. For the offenses such as kidnapping, housebreaking, theft, robbery, firearms would be imposed with a heavier sentencing by the court. In the case of PP versus Tan Eng Hock, the accused was released due to his good behavior bond for car stealing. On appeal, the court upheld the decision of 18 months of imprisonment for the rampancy of car theft. In the case of Sin Ah Q and others versus PP, the Singapore Court of Appeal reduced the life imprisonment of the kidnappers as the kidnappers does not cause any violence acts towards the victim. In the factors of previous conviction and bad records, here the prosecution will list out all the previous convictions of the accused together with the accused antecedents. In the case of PP versus Jafar bin Daud, the court enhanced 18 months of imprisonment from the convictions of 8 months of imprisonment as he was under the possession of the same offense which was done in the 5 previous convictions matters. For the factors of the position or status of the offenders, it has been and strongest aggravating factors in several cases. In the case of Dato Haji Harun bin Haji Harun Idris versus PP, the accused, who was a Menteri Besar Selangor, was charged for forgery and criminal breach of trust. He was then charged under the criminal breach of trust, and here the deputy of the public prosecutor used his status as against him. Perhaps the federal court enhanced that 4 years imprisonment was charged for the second charge and 3 years of imprisonment was charged for the first charge, and said that the accused should be a good leader towards the country. In the case of PP versus Khairuddin, the increasement of imprisonment of 18 months and a fine was imposed towards the accused as he was the credit controller of the bank and he had imposed a breach of trust towards the employer. In the factor of use of offense, where a offense of heavier committed of offense have been imposed towards the victim, then a heavier punishment such as whipping would be granted by the court. In the case of PP versus Safian bin Abdullah and another, where the imposed of maximum punishment of life imprisonment was imposed to 2 accused as they were about to commit culpable homicide not amounting to murder. For the last factor, which is the mode of committing offences in act of brutality, in the case of Jaginder Singh versus PP, the accused was pleaded guilty for planting dangerous drugs in rival of a restaurant, and then he was imposed with a 2 years of life imprisonment. Therefore, on appeal, he had appealed against the imprisonment of 2 years. Perhaps the federal court upheld the decision of imprisonment of 2 years, stating that he might have done an act of convicting innocent people against the act that they have not done it.